Thank you for joining us tonight. DPL, in partnership with SDA, is proud to present our series of webinars in Singapore. My name is Julia, and I am a Relationship Manager for Singapore Dental Protection. I would like to start with basic housekeeping. This event will run for about 90 minutes, and you will be awarded 1 CD point for attending. In tonight's session, we have various presentations, starting with Dr. James Foster's presentation on clinical slides, followed by our legal partner, Guo Wei's presentation on the Amendment Act and to explain the implications. This will be then followed by Dr. Simrit Ryatt's presentation on 3 cases. We will then conclude the night with an interactive Q&A. For any questions, please type it in the Q&A tab, and we will address them in the Q&A segment later tonight. Without any further ado, please let me introduce Dr. Guo Wei Gan, the President of Singapore Dental Association, who will be introducing the panelists tonight. Dr. Guo, please.
Thank you, Julia. And we welcome everyone, and to wish you, all of you, a safe and a blessed year ahead. I'm very glad to be here, and to SDA members, I'm greeting you from our new office at Centrium Square. So we do invite you to come and visit us whenever you can. This evening, we are very glad to have a panel of distinguished speakers to cover on the topic of consent. Right? Actually, I believe that all of us will benefit much from the experience, because even in our preliminary discussions, I took away some key messages, and one of it was that quality actually matters over quantity. Right? And you know what I mean in a few moments. Joining us from Dental Protection, we have Dr. James Foster, who is the Head of Dental Services for Asia and Australasia under Dental Protection. He qualified in 1990 and was in general practice for 16 years. He has held various roles with the Northern Deanery in Education and also worked as a clinical supervisor in prosthodontics. He obtained a master's degree in medical law in 2005 and has further obtained the MFGDP UK and a certificate in clinical education. Joining him from Dental Protection is Dr. Simrit. She qualified from the University of Manchester Dental Hospital in 2004 and went straight into private general dental practice. Shortly after qualifying, she completed her postgraduate restorative diploma from the Faculty of General Dental Practice in the UK. She has also taught at the Manchester University Dental Hospital. In June 2017, she obtained her LLM Masters of Law. Dr. Simrit regularly writes for dental publications such as Riskwise, and also regularly provides lectures and webinars for dental protection. Joining us as well to cover on the latest amendment bill is Guo Wei, who graduated from the NUS in 2016 with a Bachelor of Law. He was called to the Singapore Bar as an advocate and solicitor in 2017 and heads a team specializing in medical defense work. Guo Wei's area of practice primarily covers medical legal defense. He has also been a lead counsel in a successful appeal to the High Courts against a medical practitioner's conviction of professional misconduct. He regularly assists in a wide range of legal cases encompassing professional disciplinary hearings by the SMC, Singapore Medical Council, the SDC, the Traditional Chinese Medicine Practitioners Board, as well as the magistrate and states and high court trials. Finally, joining us is Mr. Charles Lin, who heads lawyers specializing and dedicated to medical legal defense at Charles Lin LLC. With nearly 30 years of experience under his belt, Charles has been widely regarded to be in the medical legal industry for his experience and knowledge. In 2018, he was invited by the Law Society of Singapore to provide valued opinion and responses to legislative changes to the High Courts and State Courts protocol on medical legal claims. Charles is also a notary, a public, and a commissioner for oaths accredited by the Singapore Academy of Law. So without further ado, I'd like to hand this time over to James to take us through some slides on consent. James, please.
Thank you very much, Dr. Go, and good evening, everyone. I will just share my screen. Hopefully, give me a second. There we go. Now, do you have my screen shared there? Good. 2 seconds there. Now, I presume you can see my slides there. I hope you all can. So, thank you, Dr. Go, and good evening, everyone. Thank you for joining us this evening. Again, it's a shame we can't be enjoying an event within Singapore face to face. However, we will in the near future, I'm sure, and I look forward to that. In the meantime, I hope that this session and perhaps others to follow that we've chatted to Dr. Go about will be helpful. And I wish to start this evening's discussion just by exploring what is consent and why it matters. And I would emphasize the positive in the process of obtaining valid consent, which helps build reputation and trust with patients. There is a positive which we need to emphasize. Now, we're all busy with patients and focused upon treatment we provide them. And naturally, we wish to minimize distraction and time committed to other activities. Therefore, it's understanding that in healthcare, getting a consent form signed and a box ticked becomes preferred practice over time. However, with a long-term swing away from the paternalism of doctor knows best to patient autonomy, there is an increasing onus on clinicians all over the world to ensure they obtain valid consent and evidence that process. The trends are universal, however, the specific legislation differs, and this is obviously changing here, and that is what we're looking at tonight. Now, I'm just coming out of that slide for a second to come back in to share my slides more appropriately as I'm not sharing them. Okay, thank you. I think that's a bit more successful. Apologies for the delay. So, ahead of hearing about the amendments, let us, as a reminder, review the issues involved. Now, as I'm sure you'll be aware, many complaints and cases occur not from the actual treatment, but from issues that arise before the treatment even occurred. Specifically, the conversation of consent. We all want our consent process to be bulletproof, and we often feel that if the patient signs something, then it will be just that, bulletproof. But it's not, and we will explore that. Now, when patients complain in relation to consent issues, they don't say you failed to obtain my valid consent. That's what a lawyer representing them may say, or indeed a dental counsel. What the patients say is, I didn't know there were any other options. You never explained this to me. I never knew about root canal treatment. After the root canal treatment, I would need a crown. You never told me how much it was going to cost, or you never told me there would be complications. These are essentially consent issues about information and knowledge of the procedures. Any comments and explanation we provide afterwards may well be recognized or considered allegations of being an excuse. Patients may often respond by saying, well, if it's a recognized risk, why didn't you tell me? And if you consider these comments above from the patients there, you can see how such a negative experience can so easily be reversed by communication ahead of the event. So why is it so important? Well, this is a significant statement and very true. Consent is without doubt the dominant issue in a high number of claims dealt with by dental protection. As we all know, patients may sue for damages alleging clinical negligence, and we usually associate that with a breach of duty and the standard of care. However, increasingly, patients or their representatives, instructed lawyers, will look to argue that there has been a breach of duty in relation to the consent process, particularly when the standard of actual clinical treatment stands up to expert scrutiny. It provides another opportunity to explore a claim and is often successful due to the lack of detail in the records, which is why evidencing the consent process is so important. So a claim may not relate so much to the treatment itself, but consent, in that when a material risk arises, the patient may argue that had they known of that risk, they wouldn't have had the treatment. Now, in addition to claims, colleagues may be vulnerable to criticism by dental counsellors. And as a registrant of the Dental Council, we all need to know the rules of the game in which we're playing. The guidance in Singapore provides the standards against which registrants will be measured should a complaint arise, and therefore all need to understand them. And if we look specifically in terms of consent, we'll see it's highlighted there. If a procedure needs to be performed, the patient should be made aware of the benefits, risks, and possible complications of the procedure and any alternatives available to him or her. And we talk about capacity and we talk about voluntariness on either side of that. As an aside, there's also reference to consent forms. And if we look at the last sentence there, a signed consent form does not itself provide conclusive proof of legal valid consent. And hang on to that because we'll explore that further. Now, in terms of consent, there are three components. Information, the disclosure of relevant information by the clinician, and that's to be discussed today. Capacity, the patient's ability to understand the information and to appreciate those consequences of their decision. And voluntariness, patient's right to come to a decision freely without force, coercion, or manipulation. Now, it is the information, as I said, we're focusing on, but please remember that capacity and voluntariness are equally as important, and we do see allegations relating to those that we must bear this in mind as we look at our risk. So in terms of information, as experienced clinicians, we develop a knowledge of what potential risks there are. Have we informed the patients of the risks? Now, we all know that a fractured file is an inherent risk of the endodontic procedure, but does the patient? Because if not, they cannot meaningfully have given consent to the treatment. It's when the patient is giving the patient information that should contain a rundown of all the pertinent risks and warnings. Therefore, in a case like this, it's not the file, it's not the case that the file fractured, it is the issue. The issue is that the patient didn't know it could. And that can itself drive complaints as against the actual event, particularly if the patient only finds out at a later date. Here we have a post-op photo of 6 upper anterior crowns for cosmetic reasons, and I'm sure you'd agree that's a nice result. We don't have a pre-op, but it looks a nice result. Now, we know that approximately 20% or 1 in 5 of teeth prepared will become non-vital, but does the patient? What happens if there's a loss of vitality? Well, you'll have a very happy and very unhappy patient. A curved root, difficult extraction, warning of possible fracture, possible surgical to follow. What about the option of a specialist referral? Often we see these omissions from records when complaints are made, which makes it difficult to defend the member's position. So some examples where consent is relevant to us and the problems that we see. Now, one point I do wish to make, an important issue which we will return to later, is that we may have obtained valid consent. However, that does not mean we can automatically defend any claim or complaint arising from that particular issue. For example, placing an implant too deep cannot be defended just because the patient was told it may happen. In other words, harm may be caused and it may be nerve damage. The harm caused has been avoidable and as the result of technique, not as a result of unavoidable material risk arising. If there is a breach of duty in relation to the treatment, that is where a claim in negligence would focus. So if we say to a patient, this danger might happen, that doesn't automatically mean we can proceed without care and attention. So if I may now pass back over to Dr. Guo for Guo Wei to then follow up in terms of the details of the Amendment Act. Thank you for your attention. I will come back to you shortly. Thank you, Dr. Guo. You're on mute, I think.
Thank you, James, for the sharing. We'd like now to turn the time to Guo Wei, who would cover the amendment and what the implications are for us. Guo Wei, please.
Hi, good evening, everyone. My name is Guo Wei, and I'm from Lin LLC. We are a DPL panel firm in Singapore. And today I'll be giving the legal input as to what the new Civil Law Amendment Bill means for all of you. Now, I'd just like to start. I think Dr. Guo has already kind of introduced that there will be a new act coming into force. So I'll just move on. Because this new test actually encompasses several aspects of the existing legal tests in relation to medical negligence, it is actually important for us to look at the existing legal tests. So I'm sure all of you will be aware there are actually three main aspects of medical care: advice, diagnosis, and treatment. And currently the legal tests for each are as follows. For advice, we have the Hitchcock test or the modified Montgomery test. For diagnosis and treatment, we have the Bolam-Bolito test. Now, just as a quick revision, as I'm sure all of you would have learned in university about the Bolam and the Bolito test, the Bolam test is a test which is very friendly to medical or dental practitioners, because as long as you can show that the care that you provided is accepted by a responsible body of professional opinion, this means that you won't be deemed to be negligent. Now, the Bolito addendum sort of levels the playing field a bit for patients. It merely adds that this professional opinion has to be logically defensible. So it's not just the case where you have another dentist who comes up and says that, oh, whatever you did was correct. The court also has to be satisfied that this opinion is logical. So for example, if you have an opinion that you don't have to advise a patient on a risk which is very high, let's say 50%. The court is open to the court to say that, you know, this opinion is not logically defensible and we're not going to accept it. And the Bolam-Bolito test has actually been reaffirmed in Singapore in 2002. And as of today, it remains good law in respect of diagnosis and treatment. Now, the legal test for informed consent, up until 2017, it was still the Bolam and Bolito test, but this changed following the seminal case of Hitchcock, which I'm sure most of you would be aware of. The Court of Appeal in this case made it clear that there should be a new legal test for informed consent, one which is geared more towards patient autonomy, as opposed to following the paternalistic mindset whereby we say that the doctors and the dentists know best. So this is a flowchart which was extracted from Singapore Medical Association news. And I think it's quite a good summary of the existing tests for medical negligence. We have for diagnosis and treatment, we have the Bolam-Bolito test on top. As for advice, this would be the modified Montgomery test. So stage one of this test would be whether relevant and material information was communicated to the patient. And if it wasn't, then we move on to stage two, whether the doctor or the dentist was in possession of that information to begin with. So for example, if the doctor or dentist has not kept up to date with developments in medical or dental practice, you don't know that there is another type of alternative treatment, for example, which you may offer to this patient, then you may be found to be negligent under diagnosis instead. So let's say that relevant and material information was not communicated to the patient, even though you were in possession of that information. There's a safeguard at the end at stage 3, which is whether you were justified in withholding the information from the patient. And usually there are very narrow grounds for such justification. The first would be where there's a medical emergency and the patient cannot give consent and you're unable to contact his or her next of kin. The other justification would be perhaps where the patient has informed you that he has already received a very full and complete explanation from another dentist and he doesn't want you to repeat all the information again. So turning now to the new test. So the new test would be in Section 37 of the Civil Law Act, and it states quite simply that a healthcare professional will meet the standard of care for medical advice if the following criteria are met. 1, the medical advice given is accepted by peer professional opinion as reasonable. And 2, the peer professional opinion is logical. The peer professional opinion must require you to have given information that a patient would reasonably require to make an informed decision. Two, it would require you to give information that you know or should have known is material to the patient in order to make an informed decision. And three, support the non-provision of the above information only where there is reasonable justification. And the reason why I brought you through Bolam, Bolitho, and the modified Montgomery test is because you can see elements of this in the new test. So let's deal first with what it means for a reasonable peer professional opinion. And quite simply, it just means that whatever expert witness you call in your defense must agree with the steps that you took. And the fact that there is a different opinion held by another expert witness, it doesn't mean that this is fatal to your defense. Now, the opinion has to be logical, meaning that the expert witness has to have considered the comparative risks and benefits relating to the matter. So for example, if there is a very high risk of nerve injury, for example, for a particular patient, the expert witness has to consider this as part of its opinion. So is there any compelling reason why this risk ought not to have been told to the patient? The opinion also has to be internally consistent and does not contradict proven extrinsic facts relevant to the matter. So the opinion has to actually keep up to date with medical advances and developments. The opinion cannot be based on things which are disproved by current literature or things like that. But having said that, the court is generally very slow to find that a peer professional opinion is illogical, unless it's very clear that there's something wrong with it. I think at the end of the day, the court also respects that dentists and doctors are actually masters of their own profession. So the court only comes in if there are legal issues involved. Now, as for what the peer professional opinion must require you to consider, I'll deal with each of these in turn. Information that a patient would reasonably require to make an informed decision. This refers to a standard or an average patient. In general, what kind of information would a patient want to know before he or she agrees to undergo treatment? And I think it's important for you to remember this triangle. So the risks, alternatives, and the benefits. This is sort of like a trinity of things which you have to remember to counsel the patient before he or she undergoes any treatment. As for alternatives, as dentists or doctors, sometimes we think that we have the patient's best interest at heart. And sometimes if there's a situation, for example, where the patient has a clearly decayed tooth or a cracked tooth, you might think that the only solution is to extract the tooth. But I think oftentimes we forget that another alternative is simply to do nothing. And it's quite counterintuitive for us to think of this. By the end of the day, this goes back to patient autonomy. So the patient has the right to choose not to do anything if he or she deems fit. In terms of risk, I think it's quite undisputed that most of dentists or the doctors out there would counsel the patients on the common risks, the common and serious risks. For rare and serious risks, I'm sure that there's a range of things that we would also consider. And as for extremely rare or remote risks, I think this is something that the general medical, the dental community has to come to a consensus on. So I'm not going to go into that so much. And now next, what does it mean by information which the healthcare professional knows or should have known is material to the patient in order to make an informed decision on treatment? So previously we have dealt with what do patients in general want to know. Here we are dealing with the specific patient and his or her specific concerns or queries. So for example, let's say you have a chef who comes into your clinic for a dental procedure. I think for a chef, given that his livelihood is based on his sense of taste, I think the risk of loss of any sense of taste would be doubly important to him as compared to most other patients. Another example would be a patient with sight in only one eye, and any risk of blindness arising from a dental procedure would be twice as important as well. The legislation itself actually highlights two specific categories. So patients who express queries on specific risks and patients whose medical records indicate with some level of prominence that he or she has actually expressed queries on these risks previously, even if he or she may not expressly mention these risks to you. A concern expressly communicated to you, one of the examples is here. So for example, a patient may persistently ask you about the risk of permanent blindness from the injection of local anesthesia. The risk may be minimal, not something which is routinely advised on by dentists. But if given that the patient persistently asks about it, it forms material information for him to make an informed decision on treatment. And this has to be something which is told to him before treatment commences. A concern not expressly communicated, but which ought to be apparent from the patient's medical records, which you have reasonable access to and ought reasonably to review. So this is an example of a patient with a specific idiosyncrasy. Doesn't seem like much. He has a concern about having a dry mouth after surgery, but he doesn't say anything about this to you. But of course, as dentists, as part of the continual care that you provide, you would review his medical records, and you note that his last review with another dentist 1 year ago, he had repeatedly informed the dentist that he is afraid of having a dry mouth after surgery. So this would then form material information which needs to be discussed with the patient. Now, of course, I think one of the questions you might have is how far back in the medical records would you actually need to go to fulfill your duty for informed consent? So do we have something like 10 years ago he expressed a concern? Does it mean that you have to look at the records from 10 years ago? I think ultimately in the legislation and in the parliamentary debates, Parliament has actually mentioned that this concern has to be reasonably prominent. So if it's something like the last review, perhaps the last 2 or 3 reviews, or even a note taped to the front of the file, then that is something that you would need to take note of. I think if it goes to treatment from 10 years ago, then it is reasonable for you to not really explore that concern in as much detail. Now, 3, we have covered this, medical emergencies, or where the patient has already informed you that he knows about the risks, benefits, and alternatives of the surgery, and he doesn't want to be informed of these all over again. There is then reasonable justification for you not to advise this particular patient. However, I think a common mistake, one which we often see in legal practice, is that the documentation of discussions with patients is unfortunately very lacking. So even if a patient may have told you that he doesn't want to hear the explanation all over again, you need to remember to document this in your notes. And we have put up an example of how you may do so to protect yourself legally if there's any complaints going forward. I also touched on this earlier on. So an example given in the legislation itself is, for example, the dentist is of the view that it's in the best interest for the patient to undergo a procedure, and that if you inform him about the risks of the procedure, it may dissuade him from undergoing it. The legislation has made it quite clear it doesn't give the dentist reasonable justification for not informing the patient about the risks. So if you are going to do this, I think you just have to be aware that the court can find you liable for negligence in this respect. And this ultimately reflects the shift to patient autonomy nowadays. And we always have to bear in mind that ultimately the patient's choice of treatment is paramount. Does the new act change anything practically? And our short answer would be no. You should still abide by standard practices in relation to consent taking. Importantly, make sure that your documentation is accurate, detailed, and made contemporaneously. The court has also stated that information dumps. We've heard stories of where doctors or dentists give pages and pages of information to the patient. The court has made it quite clear that this would not satisfy the test for informed consent. So in such a situation, it doesn't mean the more information you give, the safer you are. So ultimately, we have to go back to the principles of consent. What would a patient in general want to know? And what would this specific patient want to know? Don't make any decisions on behalf of the patient by withholding information on risks so as to push them towards a certain type of treatment. And I think we cannot emphasize this enough, because this is one of the #1 problems that we face when we are defending dentists against medical legal claims, is the lack of documentation. So documentation in the case notes or consent forms which state simply risks and benefits explained to the patient, this is inadequate, evidence to prove that you had obtained informed consent. So a common misconception is if you write down these magic words, it protects you, but it's not true. You actually need to detail what specific risks, what specific alternatives and advice you had given to the patient. So bear in mind that consent needs to be tailored to the individual as opposed to a general template used for everyone. It's a first good step to create your own consent form listing the various costs, risks, benefits, and alternatives to a treatment that deals with the general aspects of consent. However, you should also document for this specific patient what specific issues were highlighted to him. We have put forward some examples here. And you should also ask the patient if he has any questions and record the questions and answers that you provide to him. Now, having said all that, medical legal troubles do not arise if patient ultimately does not want to pursue the matter. So there may have been lapses, there may have been poor documentation, but if you had a good relationship with the patient is not going to complain. And if a problem arises in treatment or post-treatment, your response and reaction as perceived by the patient is key. So you need to ask yourself, am I a dentist that immediately closes off lines of communication with the patient if something goes wrong? Do I take offense if the patient accuses me of something? Or do I take steps to remedy the situation? For example, giving a specialist referral or waiver of fees for subsequent consultations. So having said that, I think we're going back to what Dr. Foster and Dr. Guo were talking about. It's always important in dental practice to maintain a good relationship with the patient. And thank you for your attention. I'll just pass the time back to Dr. Guo.
Yes, thank you, Guo Wei, for the very comprehensive sharing. Before I hand the time over to Simrit, let me just remind members that during any time of the sharing, if you have got questions, you can actually post it onto the Q&A tab that is found on the Zoom platform, right? And if you're able to answer it, we will answer it, and you can actually see the answers to the questions being posed. However, if it's a slightly more complicated question that requires multiple views, we will actually take it at the end of the sharing, right, at the Q&A session. So please keep those questions coming. So now I hand over the time to Simrit to take us through a few cases to demonstrate consent. Simrit, please.
Thank you very much. So good evening, everybody. For this particular example, the patient advised they had been suffering with a sore gum associated with the lower right eight, or what we know to be pericoronitis. Can I just check? Can everybody see my slide? Without lovely, brilliant. I want everyone to have a good look at the X-ray and think about what you would discuss with the patient if you were in this dentist position. The patient was advised they should have the 4/8 extracted, and a consent form was provided which outlined the risks associated with the lower third molar extractions, such as possible ID nerve damage and lingual nerve damage, post-operative pain, swelling, bleeding, and dry socket. The tooth was successfully extracted during the appointment. The extraction was a simple, non-surgical extraction with no complications during the procedure. Unfortunately, the patient returned the same day, and continued to return on a number of occasions with severe pain, and the dentist diagnosed alveolar osteitis, and localized treatment was provided each time. So after 4 weeks, the patient attended another dentist at a different clinic who took another X-ray. The subsequent dentist diagnosed a mandibular fracture, which I'm sure you can see over there. In terms of consent, the first downside was the failure to discuss the diagnosis of pericoronitis with the patient. The patient was aware they had a sore gum, but they didn't know what pericoronitis was, and that its occurrence can be transient in nature for most. The second issue was that there was failure to discuss the possible options of other treatments along with their risks and benefits, etc. For example, there was no discussion of any conservative treatment options, such as the irrigation of the operculum, or perhaps extracting the opposing upper eight, especially as the 2/8 had also been extracted. or perhaps no extraction at all. So the dentist, in essence, paternally chose for the patient to have the extraction and provided a consent form, or what he believed to be was a consent form. However, the reality is it wasn't a consent form at all, as it only ran through the risks for one treatment option. I hope it's clear why this isn't a consent form and why the consent form wasn't valid, as it failed to demonstrate the patient had been provided with valid consent as the diagnosis and other plausible treatment options, along with their risks and benefits, had not been included. Furthermore, the treatment records didn't show any discussions that may have been had to reflect valid consent had been obtained. In particular, the dentist failed to acknowledge other options for the treatment, such as a removal of the opposing upper eight and the risk of mandibular fracture for this specific patient due to the very thin mandibular bone. When he queried why the member didn't warn about the potential of a risk of the mandibular fracture, the dentist advised he wouldn't normally advise patients of this risk when extracting lower third molars. The dentist didn't appreciate it would have been prudent in this specific case to warn of this particular risk of the fracture, or to perhaps explore other options instead. So moving on to the next slide. Can you all see my slides moving through the sequence? Brilliant. So this particular case went to the regulator. The dentist diagnosed 4 impacted wisdom teeth and advised they should all be extracted before Invisalign treatment started. All 4 extractions were provided under local anaesthetic with a non-surgical approach on the same day. The next day, the patient experienced numbness in the lower lip and chin, lower left lip and chin area of the so the patient complained about this, and the dentist referred the patient to see a specialist who confirmed there was iatrogenic damage to the left ID nerve following the extraction of the 3/8. The dental council found the dentist failed to carry out adequate preoperative assessment to investigate the potential risks before embarking on the removal of all 4 wisdom teeth. The council and their expert believe the apices of the teeth at 3/8 and 4/8 actually, and their relationship between the ID canal should have alarmed the dentist and prompted him to consider further investigative measures to determine the definitive treatment plan, such as referral or modifying his extraction approach. Turning to the consent process, which is the focus of our day's discussion today, is the dentist failed to offer all the possible options of treatment along with their possible risks and benefits, and the dentist chose on the patient's behalf for all 4 teeth to be extracted. The consent form only elaborated on the risks and benefits of the chosen treatment, and the dentist failed to mention any other possible options. Furthermore, there was no documentation in the dentist's records about the dentist's assessment of the difficulty of the extractions and any discussions of the risks involving the removal of the tooth 3/8 with the patient. There was also no documentation to refer, discussing options of referring the patient to a specialist perhaps. And the dentist was found by the Dental Council to have seriously fallen below the standard expected amongst registered dentists. The dentist was unfortunately removed from the register for a period of 6 months. So this next case is regarding orthodontic treatment, where a general dental practitioner provided treatment using a clear aligner system. The dentist and patient were happy with the completed treatment, and at the review appointment 6 months later, the patient and dentist remained content. As I'm sure you can see, the result looks really good. So this is how the patient presented 2 years later. As it transpired, the patient had not been wearing her removable retainers, and her fixed retainer had debonded shortly after the 6-month review appointment. The patient requested a full refund. When we reviewed the records, although the dentist had advised the patient would need to pay additional fees for the fixed retainer and the removable retainer, the records didn't demonstrate the patient was fully aware she must be in retention or wear her retainers for as long as she wanted to have aligned teeth. When we reviewed the consent process further, we were also aware that at the outset, the patient had not been offered to attend a specialist or offered other types of treatment, which further undermined the consent process. As you can see, for all of these situations where there were clear breaches of duty and consent. On a positive note, all the dentists from these cases reflected on their practice, and they've made improvements to ensure that similar mistakes in their consent processes will not occur again. By sharing these with our audience today, I hope everyone will take on board these learning points, and I hope they've been helpful. Thank you very much for your attention, and over to you, Dr. Guo. I'll just end this slideshow.
All right, thank you, Simrit. Now we come to the Q&A segment.
Dr. Guo, I have a little further.
Sorry?
Little further.
Sure. Yeah. Yeah. Maybe you could.
Yeah. I'll just run through this last bit.
Yes. Yes, please.
Yeah, and
please
thank you. And I do apologise for the IT issues earlier on. I hope now you can see that, and I hope you can all hear me clearly. Good. So thank you, Sim. It is unfortunate to see members compromised by the lack of evidence consent, and I think short-term orthodontics or aligner treatment and the extraction of wisdom teeth are the two areas where we certainly see an awful lot of that, and quite large consequences as well. And I just wanted to run through, if I can, Dr. Guo, looking at 10 steps we described to help colleagues address the issue of consent. And it's interesting when we see the recommendations subsequent to the Amendment Act and what's in there, it's all in this general direction. The flow of the directions towards all of the summary points that we make, and it's a good reminder to look at that. The impact may not be an immediate turnaround, but it's basically tightening up and refreshing that helps our colleagues move forward in their thinking about the valid consent process. And 10 steps perhaps to consider. So we'll run through these, and we talked about the capacity. Is the patient old enough and capable of making a decision? That's the first one. Is that decision voluntary and without coercion? We're used to situations where members receive allegations that patients were coerced into treatment, perhaps financial incentives or risks were avoided to make it sound more favourable. Number two, what do I think is going to happen to this patient in this case if I proceed with the treatment? For example, is there going to be severe post-operative pain and bruising after a wisdom tooth extraction? And does the patient have a significant event, work or social, subsequently? What would a reasonable person expect to be told about the treatment about to be undertaken? Here, the fractured file example, or is there limited success if there is now significant medical disease? Pain and infection during treatment. These are all things that should be covered, because if they arise during the course of treatment, then it sounds as an excuse when we explain afterwards, and the patient is offset already. What is important and relevant to this specific patient? Need to ask. For example, is a public speaker or performer wishing to take on significant aligner therapy, and which may result in an anterior open bite? And obviously, there'll be consequences, significant consequences for that. Do I need to provide any information for the patient in writing? Does the patient want written information? Now, as Guo Wei very eloquently describes, the submission of pages and pages is not helpful, but there are times and situations where information is helpful, significant implant work, etc. And in providing that information to patients, that's a sensible approach. And then a conversation can follow that to establish that the patient understood upon their return, and that's reflected in the records. Do the records actually reflect the level of communication, and will they allow us to demonstrate what was said in years to come if we're challenged? Does the patient understand what treatment they have agreed to and why? Does the patient understand the costs involved, including the potential costs for anticipated complications? Crown following endoplasty, for example. Does the patient want time to consider or discuss with somebody else? And again, we see issues where people will attend a practice with a discussion about wisdom tooth extraction, and they may have wisdom tooth extracted that same day. And that can certainly lead to a compromised situation for the practitioner if there are problems arising afterwards. And have we discussed the alternatives? So 10 areas there to focus on to give ourselves a strong position. And I just wanted a couple of issues to raise. Sometimes we'll see a patient who pushes us to carry out some form of treatment, such as in this case, which is actually hopeless. When patients give consent, we need to remember the second element is in that, is it reasonable to carry out that particular treatment in the first place? Would the decision to carry out that treatment find peer support? Because we can't defend treatment that's considered inappropriate just because the patient said they wanted it done. There's that second level of, yes, the patient may express a wish for that treatment, but we have to consider that it's actually suitable in the first place. And back to this point that I raised before, if we have a consent form that says X, Y, and Z may happen, and they happen as a result of a negligent treatment, then we are not covered simply by the form. So as mentioned earlier, warning against risk does not remove the ability for a patient to challenge if that risk arises due to negligent treatment and avoidable damage occurs. So everyone will be asking, well, how can I record this? I don't have much time, I'm busy, I work in a really busy practice, I don't get paid for talking to patients, and as dentists ourselves, we can fully appreciate these points, but hopefully we can give you some guidance, and this is certainly worth a discussion. So consider utilising your staff. Do consider training your dental nurse. They can be very efficient at capturing the conversation of consent, and they also need to be properly trained to make sure the correct information is captured. But that can provide a very good medium to record that. It enables you to concentrate on the patient and the conversation. They often record the conversation in more detail in real time than you can after the event, and all we need to ensure is it is our responsibility for the notes to be accurate, so we check that following that discussion. So a treating practitioner must not delegate responsibility for the accuracy of medical and dental records to another person, but that doesn't mean that the person can't write them down. So by way of summary, don't rely on standardized consent forms. Don't consider that a signature captures everything, because it doesn't. Don't overload with the technical information. In the misconception, it's informed consent. It isn't. We actually prefer the term valid consent, because informed consent rather implies that information is thrown across. So valid consent, the information is part of that. Don't fail to get to know your patients before entering an appropriate relationship, and don't fail to ask the patient, to allow the patient to ask questions of you. And helpful sometimes to ask the patient to reiterate to you their understanding of what is being proposed. So do learn how to best structure your records to reflect the conversation. So maybe use your team. Develop a consistent process to ensure appropriate conversation of consent. And consider if the patient needs time to think, and particularly so for elective treatments or complex or expensive treatments. Give the patient time to consider it. And consider training your staff to assist in capturing that conversation, as I've mentioned. Consent is a two-way process. Now, recent events, hopefully not too significant in Singapore at the moment, mean that the conversation of consent may be compromised by the space suit that we're wearing. But we can't get away from the fact that it's still a vital part of the overall care. One last point, that the most successful dentists treat patients and not just their teeth, and as very well suggested. If you have a good relationship with the patient, they're less driven, they're more forgiving, and the trust is there to protect you if, unfortunately, when things may go wrong, which they will at some point for all of us. Thank you very much for your time. I will come back to you now.
Thank you, James. I thought you was going to your question, the first question being on the documentation. There was a member who asked whether CCTV recordings, and I do assume that includes voice recordings as well. Would it be a good way to either get informed consent, or is it a good way to record what has gone on if, for example, you're in a busy practice and you don't have time to make notes? Would that qualify as documenting consent?
Yeah, if I might jump in then, perhaps ask Guo Wei or Charles to follow up, or indeed Sim. In the past, we've perhaps looked at this with the situation of bearing in mind the relationship with the patient. If a patient walks in and you say, right, I'm going to video this because you have to inform the patient, they have to have, have to get their consent to video. If you say, I'm going to video, and the patient says, why? And the answer is, to stop you suing me, you've started on a bad footing. Okay, that was previous. It starts a relationship on a bad way. However, as consent goes forward and there's more onus, you have to start to think, is there another way around it? Now, something that's recently been mooted is if, for example, we recorded the conversation about the treatment that's being proposed and sent it to the patient for them to open up and then to listen and consider, that's turning it into a positive, and yet we're still keeping it. And that's like perhaps an audio conversation. Now, I think that's perhaps something that has real benefit. Videoing the patients has other elements and other connotations, and I'm not so sure that's where it will be at the moment. But I think the audio is something that we should be considering. I don't think we've got there yet, but I think we're headed that way. Perhaps Sim or Jens, perhaps you might have some other comments on that.
No, I think in terms of recording audio, James, as part of data protection, you have to ensure that it was stored safely. And if the patient requested a copy, you'd be able to provide them with a copy quite quickly. And other people wouldn't be recorded in there. Otherwise, they'd need to have their consent as well. I think that's my main concern with visual recording, because you'd have to perhaps go through a stricter consent process, and it'd be difficult in terms of how you'd hold that information and give a copy to somebody if need be in the future. So that would be my main concern with CCTV. But I agree with James in terms of the audio copy. Thanks.
Yeah. So then I think there's a question on the legal age to provide consent. Well, I mean, as in what is considered a minor, and in terms of, do we consider as well, for example, even if you're under the legal age, but you have the mental, you understand the issue at hand, can you give consent? Because we do see children going, for dental treatment without their parents. So what's the take on this? Maybe we'd like to get either Guo Wei or Charles to perhaps address this first in terms of the legal perspective.
Okay, I will take the question. There are various statutory provisions regarding consent. Under the Penal Code, consent by parents and guardians are needed for children under 12 years old. A person above the age of 18 can give valid consent. And under the Civil Law Act, a person under the age 18 and above can contract in their own right. That means 18 and above, you have contractual capacity. Now, under the Children and Young Persons Act, a person who is 7 years above and below 16 can give consent. Right. So there are various statutory provisions, but the case law is that you must assess for yourself whether the patient understands what you're saying and is able to give consent on her behalf. Do remember the Gilix case, which went to court about an abortion, whether a patient of 16 years old can give valid consent to take abortion pills. So, end of the day, 18 is the contractual capacity, but for consent, the most important thing is, can you support your documentation of the consent that the patient understood what you say? So for consent, I would say that there is the legal age limit is just a guideline. More importantly, does the patient understand, and do you think the patient is able to give consent? I hope that answers the question.
In terms of risk management, if I might, I think there's another element there in terms of our care of patients and the family unit. I know that if we have a patient who is there or thereabouts in terms of the law allowing capacity, I think often we see complaints from parents who are affronted that there's been treatment carried out on their child when they weren't contacted, and often that may be even when the child is over the age of consent. An overbearing parent or a strong family unit might say, why have you taken out my daughter's teeth, or why have you carried out filling, or why have you done X, Y, and Z? And I think in terms of risk management, separate law in terms of risk management, it may be prudent if there's a patient who comes in who is a child to contact the parents and say, this is what we're proposing. Or if that is unavoidable, perhaps do reversible treatment. Don't do anything irreversible. So if that's a cold extirpation on a lower six, fine, but maybe not extract the tooth unless you've had conversations with the parents. So I think there's another element on top, which is a discussion with the family, just with mum or dad, just to make that rest easier, to avoid the lashback of a family complaining if the child is there or thereabouts. And I think, obviously, in medical law, which is where these things derive from, there's more clear boundaries, but in patient management and dentistry, I think there's things we can do to avoid the risk of a parent challenging us. And those would be what I've discussed.
Thank you, James. Yeah. Okay, so there are some questions on whether DPL would provide a consent template. I think to answer that, before I pass it on to James, I think we did say that it's not about giving all the information, but giving the relevant information that is consistent with the circumstances of the patient and what they deem to be material, right? If I understand, reasonable and material for the case itself. Right, but I think members are asking, is there another member, Dr. Dominic Leong, has asked whether you can give the 10 points, the list of 10 points in conclusion, so that, for example, the elements of consent. I do believe also that the link for this lecture or some of the summary, would there be a summary that would be made available if members would like to have that?
We can certainly summarize and get those 10 points out. And I think in terms of the question, I think it's an interesting one, because why doesn't dental protection give us the information that we can get ticked and then we've got consent? And it would be back to that tick box and line of least resistance. But unfortunately, there's a couple of things there. The production of a tick box encourages the tick box approach, and clinical issues, clinical matters will not be arbiters of clinical opinion, and risks of new, dentistry marches forward very quickly. And when we have an ongoing process of clinical risk changing, we are not going to be keeping up to date with all the issues that come. The practitioner, as I mentioned before, who understands his dentistry, knows what the risks are, he's in a position to discuss them in that domain in which he works or she works. We are giving the framework from which you build your consent process, not the definitive plan. I think that's appropriate. Now, we'll certainly get those 10 points summarized and get some summary. We can get those sent out. Please bear with us a little bit of time and we'll get those put together.
Yeah. Just very quickly relating to the previous question on the consent for underage patients, I think there's a question that addresses what is considered a legal parent or guardian or caregiver that can give consent. For example, let's say an auntie brings her niece or nephew for treatment, right? And she consents to the treatment for the treatment to proceed. Is that considered is that considered valid consent for an underage patient?
I can take that question because I've actually done cases on this before, and more often than not, is a foreign domestic worker who bring the child, underage patient, to a dentist for treatment because the parents are all busy working. Okay, in this sort of situation where the caregiver is not the parent, the dentist should take care to establish that the person bringing the child is the actual caregiver, and if there's any concern, he should ask the caregiver for the contact particulars of the parents, to contact the parents and say, look, I have this patient in front of me and so I brought him here, and the complaint is this. Can I proceed to take instructions from this caregiver? Right. There was an actual situation where a caregiver brought the child to the doctor and said that, look, the child fell down and has bruises in the mouth because he fell down a drain. But when the doctor looked at the child, the doctor suspected that the child was being abused. So the doctor called the parents, and then in turn, the police were contacted thereafter. So it's important that you're always alive to the patient in front of you and the identity of the caregiver. But having said all that, once they establish that the caregiver is indeed a caregiver, then consent can be valid. But as all things, document the consent carefully.
I think the overarching principle isn't it, Charles, that what's in the patient's best interest, but it's a minefield when you've got a minor in coming to the practice without a parent who's able to give consent. You know, it may be that things are fine, but when there is a challenge, they've got the basis to present a significant challenge. So caution is urged. Make sure you make contact with it.
Thank you. Yeah, so there are some questions that I think we did address already on whether voice recording of consent taking process can be saved digitally as evidence. I think we discussed this earlier to say that firstly we need to make sure that we get consent for the recording. It must be stored properly, as with all medical records. And if the patient requests for it, we should make it available. But we can also turn it to a positive by suggesting to the patient that we record this and we send it to you so that you can review what was discussed before making a decision.
Yeah. Now I would add that that's I think where we are headed towards. What I'm not advocating is that as routine practice for today, because I still believe that if you go through the various steps, if you build a relationship with the patient by way of explanation, then you will gain that trust that won't be challenged. Now, I talked at the very beginning about there being a positive element in the consent process, and if I just maybe reflect that from my own experience and Sim's as well, when training first-year graduates, a lot of them will say, you know, I had a good experience with the patient today because they were very grateful that I explained the situation to them. In fact, they said, no one's ever taken the time to tell me that before. How kind of you, blah, blah, blah. A good relationship built. Extrapolate that across to, I mean, that's a gift that we maybe wanes after 20 years in practice. You're not quite explaining in so much detail naturally, but when we go back to do it and the patients are saying, you know, right, I've explained, I understand, thank you, then you've got that, you've got the trust built with the patient. And I think it's an important element. The recording gives an opportunity for that for the challenge, but if we can avoid the challenge in the first place by transparency, bringing the information level, because we've got this disparity information, we share that information with the patient, and I think we're in a better position. And I would urge members to do look at some of our workshops when we get back to face-to-face, because we have workshops about consent, about adverse outcomes, etc., and they are well valued, and I would urge members to explore those further.
Yeah. So thank you, James. I think James has highlighted a very important message, which is really that while consent is important, it is not the be-all and end-all. Actually, it really underlying it is really good communication with the patient. So if you actually communicate well with the patient, it actually helps to avoid a lot of problems down the road, or patients coming after you should there be unfavorable outcomes or complications.
Yeah.
Right. So moving on, I mean, I have one question. Before we go on to the questions submitted by panelists, we are talking about different options and even having non-treatment as an option, right? What if, for instance, some of the options may actually do more harm to the patient? For instance, if let's say there's a root stump and this patient is going to undergo bisphosphonate treatment, right? So do we advise, for example, in this case, that non-extraction, right, is an option, even if there's a potential for it to cause harm down the line in the future?
So, please.
I was going to say, if it's a reasonable option to keep the tooth, if you could safely restore the tooth and it could last for, you know, inevitably, then yes, it would be an option. Obviously, if the tooth was unrestorable, it wouldn't be a reasonable option to offer. So it's just on a case-by-case basis, really. You're not giving the patient every single possible option. You're just assessing the case on its individual merits and offering the reasonable options, which you would actually do, say, on a close relative. So you're seeing your patients as you would do if you were seeing your mom or a loved one, and you're just offering all the reasonable options that you would do.
I think you can minimize the risk in relation to areas of contention where there's obviously an underlying medical situation. If the patient sees you make an effort to liaise with the medical staff taking care of them with their consent, you're showing an acknowledgement situation, you work with the medical experts, you act on their recommendations, involve them in the process, then there's far less likely to be a challenge should there be a problem after treatment than if you just said, well, I understand that's a risk X, Y, and Z. I don't need to speak to the doctor. So I think it's taking a holistic view of the overall patient care and the wider aspect.
Yeah.
Okay, so I did note that on the question and answers, there are certain questions which I think are important questions. However, they are not related to consent. So if I could just propose that for these members, what we do is that if there's you can write to us and we will try to answer you separately on some of the concerns. Things like if a hostile patient turns to social media or they try to put you down on social media because of an unfavorable outcome or because of some reasons that they're unhappy, what should you do? Or that does unfavorable outcomes and complications equate to negligence? I think these are important questions and relevant questions. However, we would take the ones relating to consent first. And then if we got some time, we may address that. Otherwise, do feel free to email us and we will try to address that. The Dental Association will try to address that for you as well.
Happy to deal with any questions that may arise.
Yeah. So I think that the thing is with DPL create templates and all this, we did say that we're going to summarize some of the principles instead of what good consent taking is, right? Okay, so one of the I did note that one of the requirements on consent taking is what is really material to the patient, what they have highlighted or they have specifically brought up as a query, right? What if, for instance, we have some patients that are slightly a bit more anxious or paranoid and they want to know everything and they say that, I just want to know every possibility that could go wrong, right? I'm just afraid. In such an instance, how do we deal with it? And if, for example, we miss out one of the risks, right, would then that be held against us?
I'm happy to answer that. I think if you are you're dealing with a patient, there's a couple of points. What is reasonable? What is reasonable? You're still coming from a background of bolum and bolitho. You've still got that background of what is reasonable. Okay, you still have an element of that in there. If the patient's coming and saying, I want to understand absolutely everything that can go wrong, then you are in a position where you're going to be alert. You're going to think, okay, we've got you might say, we've got a live patient here, we've got a situation, I need to bear that in mind, and you need to be covering more, okay, more of what is going on. When I first was teaching, I had a student who was very risk aware, very risk averse, and almost unfortunately became obsessed with it. So an occlusal amalgam had the whole history through to the loss of the tooth and how it would be replaced. It was X, Y, and Z, the whole story. What could go wrong? What could consequences? And that's unreasonable. I think when a patient is saying, what could possibly go wrong, you aren't in a position then to have to give the most nth degree, all of the indices of stuff that could possibly go wrong. You've got to be reasonable and what is practical and what is reasonable. You need to be careful with a patient like that because there's a potential, obviously there is an issue there. Is it someone who needs to be referred to sedation or some other to reduce the risk that the anxiety that they feel over treatment? But to answer the question, you go that bit further, but only what is reasonable. Sim, would you have anything to add?
No, that's exactly what I'd say. I guess it's your opportunity to steer the conversation to reasonable options and just try to, support the patient as much as possible in terms of answering as many of their questions as possible, but staying in the constraints of what all of our colleagues would offer in terms of reasonable choices and options for treatment.
And I think if I was hoping to be that, hoping as a patient for the longer term, I'd wish to sit the patient up and just explore why they're asking those questions. What is it that's behind all of this? Have they had a previous bad experience? Have they got stories from other members of the family, or what's the experience behind that? So if you could drill down in a few minutes and just try and set the scene for the basis for a relationship going forward, because obviously there's something that's driven that behavior.
All right, thank you. There's a question on financial information signed by the patient. If the patient is undergoing sedation for dental treatment, must the patient make payments before the sedation, or can it be done after?
Well, in terms of, and I'll touch, let's have to go in a minute, but in terms of capacity, the issue about capacity comes up in the sedation. If a patient is sedated, they're not in a position, they don't have capacity to give valid consent. Perhaps others might follow up on that from their experiences.
Yes, you try to have all your discussions at the assessment appointment or before the sedation started. So perhaps maybe consider taking payment before the treatment, before sedation has been provided. And obviously your consent discussions before the treatment, before sedation was provided, discuss all the possible risks, what could go wrong within the treatment with the patient at that point. And really at the end of the treatment, the patient should just be in the recovery and should be, going off with their the person who's looking after them, driving them home or whatever. So no, it would be inappropriate for the patient to make payment after sedation.
I think there needs to be a lack of, it needs to be a clarity, sorry, there needs to be clarity over the charges beforehand, clarity over the treatment to be provided. And if you look at the situation that can drive complaints, say a partner at home, a partner at the surgery realizes that something is twice as expensive as it's going to be, or they've done something different, and when was the patient asked? They're asked after they've been administered the sedative. There's a danger, there's a perception, unfortunately, there's a perception that might have been a bit disingenuous. The patient's been sedated, we've got more, you never know how people can see things or react, and that can drive a significantly adversarial complaint process or claim. Gentlemen, sorry.
Yeah, so maybe relating to that question really is that, for instance, let's say a complication happens when the patient is under sedation. Do we then inform the patient immediately after he's out, or we put a review appointments and then we only inform the patient a bit later on?
So two things. I think if during the procedure there has to be a change of direction, if that direction, then this comes down to the clinician in clinical management. If that change in direction is wholly significant, like this ain't going to work and we'll have to rethink, you stop and you start again. If it's a slight amendment, but it should have been discussed before. For example, if you're doing a preparation and there's a risk of a cavity and there's an exposure, you have to start RCT. That's the sort of thing that should be covered beforehand. But if you've got a complete change of direction, that should be discussed after. And I would be wanting to let the patient recover and then revisit that.
Yeah.
Okay. Dr. Dominic Leong asked whether there has been a test case since the introduction of the amendment, but just want to check, Charles, has the amendment been passed or is it being proposed to be passed?
Since Guo Wei gave the talk on that one, I think I'll leave it to Guo Wei. Guo Wei, can you answer that one?
Yeah, so what has happened is Parliament has already passed this into law, but it hasn't come into force because that will only be done when the minister fixes a date where it comes into force. So just to answer the question directly, there hasn't been a test case for this particular test, but in our view, it's substantially similar to the existing modified Montgomery test. So perhaps it just gives more clarity as to how the court may come to a decision in respect of the expert evidence which you might want to put forward in your defense.
Yeah. Okay, so I think there's a question from another member. Our question: if are patients allowed to record consultations without permission, and should they then record it without permission? Is that then, of course, to add on to that question is that should they then submit this as evidence of improper consent? Would that be accepted? Or
I'm not sure I heard the beginning of that, Doctor. Sorry, if a patient.
Yep. So let me repeat. So sometimes patients do record their conversations with their dentist without permission, right? And firstly, is it allowed? And later on, let's say that the patient then submits this to the dental counsel to say that this is my conversation with the dentist, and the dentist did not tell me about this complication because I've got this record. Is it admissible as evidence?
Well, I'll pass to Guo Wei and Charles, but just I do reflect, and Sim probably remembers this, there was a case in another country in Asia where the dental council did take it into account, which there was some discussions about. Gentlemen.
Okay, this is an interesting question because a case came out recently where the dentist suddenly discovered that the patient has been recording the consults on the third consults onward because of there was a complication. Okay, there is no law against a patient recording a consult. Okay, but before a dentist wants to record a consult, because you are a professional and you are held a higher standard, you need to ask the patient's permission that you can record the consult. So yes, unfortunately, there are different standards here. Layperson can record, professionals can only record if you had the patient's permission. Now, if the dentist finds in the middle of a consult that he finds that, or he suspects that the patient is recording, the dentist can stop the consult and say, I do object to you recording the matter. If you want to record, then I will have to stop the consultation and perhaps refer you to another dentist. Now, what is the probative value of such recordings before a dental council or before a court of law? Now, we have encountered this, and we need to obtain from the patient the whole recording, because oftentimes they're not, the patient will truncate or choose to only give certain parts of the recordings. So if the patient does submit it, legally the patient has to go through a certified transcriber to carry a transcript, and we on our part will ask for the full recording, and in a very extreme case to check whether there's any meddling with the actual recording. It is possible to meddle with our recordings. We know we've done cases where we've seen them adjusting the recording. So yes, they are probative value, but subject to strict standards.
Sorry, just to jump in here, it will be a breach of the SDC ethical code and ethical guidelines for dentists to make surreptitious recordings of consultations or treatments with patients, merely for the purpose of protecting themselves from possible complaints. So, I mean, this is something that applies only to dentists, but if dental practitioners suspect they are being surreptitiously recorded, they have the right to refuse this under the ethical code.
Thank you. Yep. So I think time is. We're coming close to 8:30, and before we end, I would really like to thank all the participants and everyone who has made time to join us for this session. We do hope that you have it has been educational for you and it has been beneficial to your practice. I would also like to thank the panelists who have made time to come during this evening to share with us from their experience, as well as to really provide us some insights on this topic. Before we end, I would like to also give DPL a few minutes to share with members or those who may or may not be members what are the benefits of dental protection, how they address cases, and what's the approach in which they take, to ensure that the outcomes are good for both the dentists as well as the patients.
Yeah. If we pass over there, thank you, Dr. Go. Just as passing over to Julia, one comment I might make, if I may, in terms of this approach, and there's an issue from a patient, please get in touch with us at the earliest stage, because resolving a matter proactively before it escalates to a claim or complaint is in the best interest of all parties involved, and we're here to help, and if we can do it properly for you, we always will. We're on your side, we're there for you. Thank you, Dr.
And Julia, over to you.
Thank you, Dr. Go. So in the DPL, we are not for profit. So just to actually do the closing remarks for the webinar. So our philosophy in DPL is to support safe practice in medicine and dentistry by helping to avert problems in the first place. We do this by promoting risk management through our workshops, e-learning, clinical risk assessments, publication, conferences, lectures, and presentation. So our team offers doctor-doctor, dentist-to-dentist support and advice, including a 24/7 emergency phone line and a full risk management education program. Every day, we help our members to deal with difficult issues arising from this clinical practice, such as medical legal issues, ethical dilemmas, adverse incidents, and patient complaints. With a large worldwide team of medical legal specialists, whatever your questions, problem, or dilemma, we can help you to get your answers. So many of our medical legal advisors are dual qualified in both medicine and the law. They are all trained extensively and they focus solely on medical legal matters. If you are concerned about any issue that have occurred in your clinical practice, so we encourage you to actually get in touch with us immediately. As a member, you can actually request for help 24 hours a day, 365 days a year through our DPL website. So some of the webinar attendees today are not current DPL members. If you're interested to join, you can actually fill up the application form. In fact, you can actually scan the QR code, or alternatively, please download and send your application form to the Singapore Dental Association. So for any further questions, please go to our local website. Alternatively, please contact me. Thank you for your time tonight. I hope you have enjoyed the session today. Please keep safe. And for those that have opted to receive our promotional items, I will be following up shortly with you. And for today's recording, I will be sending you the link for you to actually review our session. Good night, everyone. Thank you for your time.